Hi everyone, and thanks for joining us for today's webinar, Managing Employment Contracts where Program Funding is Coming to an End. My name's Penny Sullivan. I'm one of the Sector Sustainability Coordinators at Community Legal Centres Queensland. First, I'd like to acknowledge the traditional owners of the land on which we are holding today's webinar. In Meanjin, Brisbane, they are the Turrbal and the Yagara people. We pay deepest respect to elders past, present and emerging. As this webinar is being viewed by people across Queensland and Australia, we also pay respect to the traditional owners throughout the country. We recognise Aboriginal and Torres Strait Islander peoples as the traditional custodians of the land in Australia and their continuing connection to land, water and culture. We acknowledge the stories, traditions and living cultures of Aboriginal and Torres Strait Islander peoples and commit to fostering a culture of learning from and working with First Nations peoples in the spirit of reconciliation and access to justice. We extend a warm welcome to any First Nations peoples joining us today. So I'm very pleased to now welcome Aroha Greenwood, who's a Senior Associate at Minter Ellison. He's going to discuss the issues associated with managing employment contracts in circumstances where funding is constrained or ending. Aroha will cover legal considerations when preparing fixed-term employment contracts, creating fair and transparent processes when there are limited ongoing employment opportunities, and legal risks and challenges. I'll let Aroha share a bit more about herself when I hand over in just a moment. But before I do that, just some quick housekeeping. Today's webinar is being recorded and we'll have the recording available to download later today or tomorrow. A link for the PowerPoints has been emailed out to everyone who registered and can also be downloaded from our website. And they're also available from the handout section of the GoToWebinar control panel. We do encourage you to ask questions. If you type your question into the question box on the control panel, we'll read your question out. We will hold questions until the end of the presentation, but do feel free to type them in as you think of them. So that's it from me for now. I'll hand over to Aroha and talk to you again at the end of the session. Thanks, Aroha.
Hello and good morning, and Kaya from Noongar Whadjuk country. Thank you, Penny, for the beautiful acknowledgement to the country. I'm just checking that you can hear me okay. Good to go. All right, we've got a lot to cover today. So I'm going to get stuck in and start on the next slide. I'm just by way of introduction, I'm a Senior Associate in Minter Ellison Perth team. I've been a practitioner in Brisbane as well as in Western Australia, so greetings to everyone over there in beautiful Queensland. So while we're covering management of employment contracts when funding comes to an end, I'm actually presenting to you today in two parts. The first is a very important update on the position of fixed-term contracts and the law, which are a result of upcoming changes to the Fair Work Act 2009. And in the second part, I'll be focusing on managing the employment contracts in circumstances where funding is coming to an end or is restricted, as Penny noted. Basically, how to manage effectively the expectations of employees and the legal risks associated. And I'm talking about fixed-term contracts because many of you will use them, including in combination with permanent ongoing employment relationships or arrangements as part of your org structure. So let's get started with fixed-term contracts. What is a fixed-term contract and why has the law changed? Well, until recently, there was no specific legislation applying to fixed-term contracts for employees at the federal level. And that's changed now that the Labor Albanese government, through IR Minister Tony Burke, introduced a raft of legislative change in the form of the Fair Work, Secure Jobs, Better Pay Act, or the SJBP Act, as we call it, which was passed in December 2022. Now, the revisions brought about by the SJBP Act have a staggered implementation and some changes are already in effect. But the last chunk of change under this legislation comes into effect on 7 December this year, 2023, and includes restrictions around fixed-term contracts, which is why I've started this presentation to you today on this topic. So what is a fixed term contract? Generally speaking, a fixed term contract is an employment contract which specifies a date on which the contract and the employment relationship between the parties will be automatically terminated. Now, maximum term contract also specifies a termination date, but it will provide options for either party to voluntarily terminate the contract before that final date. The difference is that termination prior to the end date for a maximum term contract would not give rise to a breach of contract claim for the balance of the term of the contract, provided that the notice provisions are complied with and that the termination is otherwise lawful and reasonable. And this is because there's already an expectation that the employment may terminate earlier than the final day of the term, whereas in a fixed term contract, the entire contract is premised on the idea that the contract will be for the entirety of the term and will not conclude earlier. Now, the SJBP Act will make its changes to fixed term contracts in December, as I said, and the explanatory memorandum for the bill states that while these contracts continue to have a legitimate purpose, their ongoing use has become another form of insecure work, and fixed term contracts exacerbate job insecurity. Now, whether or not you believe that's the view of the Albanese government, and that's the reason for these changes. So, according to the explanatory memorandum, the amendments would limit fixed term contracts for the same role to 2 consecutive contracts or a maximum duration of 2 years, while preserving the legitimate use of fixed term contracts in certain circumstances. And it's that preservation of the legitimate use of fixed term contracts in certain circumstances that I'll be talking about in a moment. What's really important is that the SJBP Act bundles up maximum term contracts, or outer limit contracts as it refers to them, into the prohibitions. So when you hear me talking in this presentation about the prohibitions on fixed term contracts under the legislation, I'm talking about both. I'm talking about any contract that specifies termination at the end of an identifiable period, which is how the SJBP Act describes them. In addition to prohibiting specific types of fixed term contracts, the Act also prohibits anti-avoidance strategies, so that employers are prohibited from terminating an employee's employment for a period and then delaying re-engaging them to re-employ them, or engaging another person to perform the same work as an employee whose employment has ended, or changing the nature of the work an employee is required to do, or otherwise altering an employment relationship to get around these restrictions. Lastly, and very importantly, for anybody who is going to be issuing fixed term contracts, the Fair Work Commission will soon be preparing and publishing a fixed term contract information statement, which must be provided to all employees before commencing employment on a fixed term contract. So I'll look into these restrictions, the new restrictions and their effect in some more detail. From 6 December, the following types of non-casual employment contracts cannot have a specified termination date. This includes if the contract provides that employment will exceed 2 years as a whole, has an option to renew, which if exercised, employment would exceed 2 years, or is a consecutive contract to a previous contract for substantially the same work, and when added together, the employment would exceed 2 years. This is all in the new Section 333E of the Fair Work Act that will come into effect in December. If the contract provides an option to voluntarily terminate early, for example, a maximum term contract, but it still exceeds 2 years as a whole by an option to renew, or through consecutive contracts, it will still be an invalid term contract. So this is where the maximum term contract is caught. However, if an employee enters into, or employer and employee enter into a fixed term contract within the meaning of the legislation, the effect of this is that the term that ends the contract after a certain period will be considered invalid. and it will attract a civil penalty of up to 60 penalty points for employers who use those contracts without a valid exception. I'll be discussing the exceptions on the next slide. So to give you an idea, 60 penalty points under the Fair Work Act is equivalent to, and I'm going to get these right, someone might catch me out, there's $13,320 for an individual and $66,600 for a body corporate. So the explanatory memorandum makes very clear that the amendments are designed to shut down the circumvention of this prohibition through all types of contractual arrangements, and the anti-avoidance measures mentioned previously, which are all housed under section 333H backs up. So before you panic, we do have exceptions to these limitations, and I've included the relevant subsection here, 333F. The prohibitions under 333E don't apply in relation to a contract of employment entered into by a person and an employee if the employee is engaged under the contract to perform only a distinct and identifiable task involving a specialised skill, or the employee is engaged under the contract in relation to a training arrangement. C is the employee is engaged under the contract to undertake essential work during a peak demand period. And the example given under the explanatory memorandum is seasonal work, for example, fruit picking. D is the employee is engaged under the contract to undertake work during emergency circumstances or during a temporary absence of another employee. So that includes in the, as explained as an explanatory memorandum, parental leave, sabbatical, long service leave, or an absence relating to workers' compensation. E is in the year the contract is entered into, the amount of the employer's earnings under the contract is above the high income threshold for that year. Now, there are also provisions in this particular section that allow for the pro-rationing. We've got a part-time employee, so there will be calculations in effect to stipulate how to calculate what the threshold is for employees who work part-time. The relevant one that I'm going to draw your attention to is F. This might apply to many of you, and many of these exceptions may apply to many of you, but F is that the contract relates to a position for the performance of work that, in subsection 1, is funded in whole or in part by government funding or funding of a kind prescribed by the regulations for the purposes of this paragraph. Now, unhelpfully, there is not yet a regulation which describes what funding of a kind prescribed by the regulations means, but it may indeed come into effect at a later stage. Subsection 2 says that the funding is payable, F2, the funding is payable for a period of more than 2 years. And 3, there are no reasonable prospects that the funding will be renewed after the end of that period. Now, what's clear from the explanatory memorandum is that funding must directly finance the employee's position either in whole or in part. Now, while the funding must be directly for the work, it can be a partial contribution. There's no suggestion that it must be a certain percentage, e.g. half or more from the government. G relates to employment of a governance position, so that has time limits. So you might have somebody, for example, working for you on a fixed term contract as CEO, and the governing rules of your association might allow that to occur. Subsection H permits fixed term contracts where a modern award that covers an employee includes terms that permits fixed contracts for a term greater than 2 years. Now, it's important to know that even if your particular organisation employs people under the terms of an enterprise agreement, if the underlying modern award contains provisions which allow fixed term contracts, then the fixed term contracts will be permissible without the enterprise agreement needing to be varied. So once the legislation comes into effect on 7 December 2023, if you've got an enterprise agreement and the underlying modern award allows fixed term contracts, you don't need to be too concerned about that. On that, I'm just going to make sure we go to the next slide. So I've just pointed out a number of the exceptions that we want to draw your attention to. We've already just covered them, but the one where employees are engaged to perform a distinct and identified task involving specialised skills. Unfortunately, we don't have a great deal of description in the explanatory memorandum about what that means. But for now, the key to protecting your organisation will be in how you draft your contracts going forward to identify whether a relevant exception applies to your organisation. I've already highlighted the exception in 333F1F, which is that the contract which the employee is engaged in is funded either wholly in part by the government. But I draw your attention to the fact that this funding is payable for more than 2 years, and there's not a reasonable possibility that it will be renewed. In relation to, I just mentioned the applicable modern award. We've had a look at some of the relevant modern awards that might apply to the organisations on this call. For example, the SHADS award does not currently contain a clause permitting fixed-term contracts. Although that bullet point says it's unlikely to be amended to permit fixed-term contracts, that's slightly misleading. What we should be saying is, really, we don't know yet whether the Fair Work Commission has any intention to amend any of the modern awards to update them to allow fixed-term contracts. We continue to monitor the Fair Work Commission website in that regard. With all of these exceptions, the evidentiary burden of establishing their existence and their validity lies on the employer. So this means that in any proceedings for a civil penalty for contravention of the prohibitions, under section 333F4, the employer bears the burden of relying on the exception. So it's stipulated in the explanatory memorandum, and this is part of our advice to you in your auditing arrangements, that it would be best practice for the employer to include in the exception that they rely on within the terms of the fixed term contract and the basis on which they consider the exemption applies to their burden. So I should note here that the kind of civil proceedings contemplated are contraventions of the general prohibitions on the fixed term contracts, which are included at section 333E, and that the people who may bring an application in relation to a civil penalty provision under the Fair Work Act, the changes will allow prospective employees, employee organisations and a Fair Work inspector from the Fair Work Ombudsman, the FWO, to bring a claim for contravention of this provision. That's very important to note. So the FWO will have power to investigate and to bring proceedings in relation to contravention of these provisions. Lastly, it's also important to note that it's a civil remedy provision of the Act that if an employer fails to give an employee a fixed term contract information statement, and so that will be published, and that has to be provided every time an employer enters into a fixed term contract with their employee. A person will be able to bring these claims through the small claims division of the Fair Work Commission. On the next slide, I've highlighted a new provision, section 333L, which we think is going to get quite the workout from December onwards. This section allows the Fair Work Commission to deal with disputes in relation to fixed term contracts. Now, interestingly, the first step compels resolution at the workplace level, and the explanatory memorandum states that this provides for a process for the employer and the employee to resolve disputes. Now, I just said to you that clearly the legislation contemplates that prospective employees can bring claims of contraventions of the legislation, but it's a little bit unclear how a person at the workplace level will endeavour to resolve a dispute if they're not employed. But I do draw to your attention that a prospective employee could also be someone who you currently employ on a fixed term contract and who you propose to re-engage on a fixed term contract after the expiration of that term. So they could bring a claim under this section regarding whether or not the proposal to enter into a new fixed term contract is legitimate. Keep in mind that if an employee, an existing employee comes to you with a concern regarding their contract, this section will compel you to attempt to resolve it through a dispute resolution process. And obviously the last point is that the Commission can then deal with it by way of resolution in arbitration or mediation. Now, the last slide in this part of the presentation is, what does this mean for your organisation? So steps we're recommending. Step one is to undertake an audit as to who is currently employed on a fixed term contract in your organisation, why they are employed under a fixed term contract, and critically when their contract is due to terminate. Ideally, you'll have an Excel spreadsheet, for example, of showing when your fixed term contracts are due to terminate. Your organisation can continue to utilise any existing fixed term contract arrangements, and you don't have to discontinue those which would otherwise contravene the limitations if they are entered into before 6 December this year. The contracts which are due to terminate on or after this date, so when the fixed term contract prohibitions come into effect, 7 December, will be the ones you need to address first as a priority. Would you ordinarily be reconsidering a further fixed term contract for these employees? Then you need to prioritise step 2, which is getting advice as to whether the exception applies. I should add that the SJVP Act has already introduced changes that prohibit, for example, pay secrecy, and have introduced a raft of changes. So it's a good idea anyway, even for your ongoing employees to, your permanent employees who have ongoing employment arrangements, to just undertake an audit to check the health of your contracts. Step 2 is to get advice as to whether one of the exceptions may apply to your organisation or to the individuals in your organisation. Note the exceptions may apply to specific individuals, such as those earning above the high income threshold, which I'm trying to draw on my brain is around 160,000, maybe a little bit lower. It also applies to particular classes of employees, such as those employed to work on specific projects or those covered by an award. So make sure you cover all of the exceptions in your advice. Step 3 is actually reviewing your fixed term contracts for compliance, and you will need to reconsider the duration of your fixed term contracts, your options to renew if you have any. And if an exception applies, then obviously this should be noted in the contract as an acknowledgement between the employer and the employee. Now that concludes my part in relation to fixed term contracts and the changes under the law. So now we'll move into the next topic about managing fixed term employment contracts where funding comes to an end. And this topic is largely premised on the assumption that we're talking about a situation where you will have employees falling within one of the exceptions under the Fair Work Act. I'm focusing mainly on fixed term contract arrangements, but many of these principles also will apply to your employees who are on ongoing employment, and you may need to make a decision in relation to whether or not they are made redundant as a consequence of some of the changes to your organisation. The employee life cycle model is a relatively well-known and is a very basic yet useful expression of the stages of employment. It's a model used in human resources, but as lawyers, it's also extremely useful in reminding us employment lawyers where an employer needs to exercise due diligence in respect of the processes that apply to their employees. Because at every one of these stages of the employee life cycle, if the employer is not following a process, then there are legal risks either immediately or further down the track at a later stage of the employment life cycle. Now, at this point, you might be asking, why is this important if we're talking about the end of an employment relationship and about managing the termination of employment contracts where funding comes to an end? Well, it's simple, because if you haven't set the expectation, around the status of the fixed term contract at the beginning, or around funding generally, and that funding will ultimately come to an end. At the point of attracting the right candidates, so at the point where you start looking for people, you increase the exposure to legal risk and having a disenfranchised group of employees at the end. This is why it's very important now to reflect on what we've just discussed in the first part of the presentation about making sure that you've audited your contracts so that when you get to the attraction and recruitment stage, you're ready to roll. I'm going to run through stage 1 and 2 quite quickly. The attraction stage from an HR perspective is including attracting the right talent and candidates from a role, but from a legal perspective, you want to be sure that you're disclosing the nature of the engagement at the earliest possible stage from the job advertisement and during the interview process once you've shortlisted eligible candidates. You might even want your candidates to acknowledge on a form, if that's your process, that they are applying for a role which is for a fixed term or a maximum term, and they understand that it's subject to government funding or whatever exception applies in relation to that particular employment. Bear in mind that the difference in the maximum term contract and the fixed term contract is that the maximum term contract will allow you to terminate earlier without having to pay the remainder of the term, but a fixed term contract won't. So your decision on whether to go with a fixed term contract or a maximum term contract will be an operational one and will depend on budgetary constraints, your funding arrangement, and it will take into consideration the restrictions and the exceptions under the Fair Work legislation. Stage 2, the recruitment stage, is all about getting your contract right, and this is where our earlier points about the fixed term contracts exceptions are going to be especially relevant. You want to be firstly determining the kind of contract to use, as I said, the maximum term or fixed term. If you go with a maximum term contract, you should ensure that you include provisions enabling notice of termination by either party prior to the final termination date. And so these notice provisions must be consistent with the national employment standards. And that's under section 117 of the NES of the Fair Work Act. You will need to insert a clause in the contract to say that the employee acknowledges that the contract is an exception to the prohibitions on fixed term contracts, if that is the contract that you're entering into. And remembering that the onus is on you as an employer to prove that the exception applies, and that the explanatory memorandum under the SJBP Act states that you should be including this term in your contract as part of your due diligence. Also in the recruitment stage, you should be ensuring in the first instance that you've identified the appropriate underlying modern award to your organisation. Now, this should be quite obvious, but in this, as I've identified in the auditing situation, it might be you can probably keep abreast of whether or not there is an ability for fixed term contracts under your modern award, and you should stipulate as much in the contract of employment. I've lastly noted that you must give a Fair Work fixed term contract information statement, and that, as I said, is a civil penalty provision if you don't do that at the time that you recruit your employees. Now, you might be wondering why onboarding would be important to managing the end of contracts, and surely that it's the contract itself that's the important piece of the puzzle. Now, onboarding is critical from a legal perspective in employment law in relation to your training and induction into an organisation's policies and procedures. So whilst it's a very quick component of the employee life cycle, it is the training and induction into your code of conduct, performance management processes, grievance resolution policies, discrimination, harassment, and the like is very important in terms of setting the standard of conduct for your employers and explaining all the operational processes for your organisation. And you want these policies to be good, but you don't want to incorporate them as a contractual term of your contracts, because as an employer, you want to have the right to review and amend your policies accordingly. They're unilateral documents, and you don't want to incorporate them as terms of your employment contracts. But you want your employers to understand at the beginning of their tenure that there will be, for example, scheduled performance management reviews by way of example, and or that any arrangements in selection for further terms of employment will take into account a merit review. This is where we're getting into the development and the retention stages. And I'm going to repeat a little bit here where I'm merging those stages into one. But what I want to focus on is what I just touched on in the onboarding process, which is about setting the expectation of employees at the beginning through the well-articulated policies and procedures. So in the retention and the development stage, you're going to be executing the policies and procedures. You don't just onboard and forget. You don't set and forget. You critically, when expressed well and adhered to, these processes and procedures will assist you when you're offboarding some employees, for example, but not all. So, for example, in a situation where 4 employees do the same job, but you've only got funding now for 2 of these roles, what do? You've got a situation, if you have a policy, for example, that allows for regular dates for feedback and reviews, which you execute properly, then you have the information you need to make a merit selection for the 2 positions which will be available. And at the onboarding stage, you will have set the expectation for your employees that their employment is funded, and that at the end of the funding stage there will be a review, for example, and into who will be considered on a merit basis for any positions that might be available. You might want to tailor your performance policies to expressly state the dates on which your reviews take place. Now, the position description is often overlooked and underrated. Often organisations won't have a PD, or the PD is old or not fit for purpose, or it's poorly worded. A PD should be drafted so well that I can take that document as an employment lawyer and I can look to the relevant modern award or enterprise agreement that it might apply to that role, and I can correctly classify that role to identify what the minimum wage is for that position. It should be drafted well enough that the employee understands the criteria against which they're going to be assessed during their performance reviews. If your PD is wrong or not fit for purpose or assigned to the wrong employee, you will have a fundamental misalignment between what the manager and what the employee believes the role to be. For example, the PD doesn't specify the role has supervisory responsibilities. This could be the difference between one classification and another under an enterprise agreement or a modern award. And it's also the basis on which the employee can justifiably say that the expectations of their role were unreasonable if it's not specifically stated in there that Joe Bloggs is expected to supervise a junior lawyer, for example. It's critical to get the PD right and get it right for the right person. And so when you're undertaking your performance reviews, the PD should form the basis of the assessment of the employee's performance. There's no specific formal procedure for conducting performance reviews under legislation. However, it's a basic element of procedural fairness, and that there is, there's a basic element of procedural fairness, that there is transparency and consistency with the manner in which an employee is assessed. A performance review should involve feedback from the employee and whether they agree or don't agree with the feedback. So it might be what some people call a 360-degree review. The performance review should also be setting targets which are revisited at the next date and which follow the SMART model, the specific, measurable, achievable, realistic and timely model, which is set in reference to the PD. So it's at this point where you are identifying those employees who are not performing well, or those employees who are performing well and have promise, that will assist you at a later stage when you start the project managing the end of an employment relationship. I'm not sure if you can see the dot on the screen. I've put in just a dot on the timeline between the retention and development, that where we see the project management determination of contract beginning, and this is where the legal risks arise. So if you've followed your internal processes and procedures, you've already got your bank of information, whether your employee is performing to standard, whether they're adhering to expectations in relation to code of conduct, and so forth. Now we're talking about the point, crunch time, when you are looking at it's apparent that funding is either ending altogether, you've got further funding, but it's not sufficient to keep everybody on board. And what do you need to tell your employees, and when do you do it? How do you do it? And I've been asked previously whether the consultation provisions under a modern award or an enterprise agreement will apply in circumstances where funding's coming to an end or there's a change to funding, which means that the organisation needs to restructure and reorganise. Now, it's going to depend on how your organisation is structured and how your contracts are structured as to whether or not this consultation obligation kicks in. Now, I've just, excuse me, take a sip of water while I speak. I've excerpted there the consultation provision from the SHADS Award, which is relatively standard across modern awards. And in an ideal world, you might have everyone on fixed term contracts, and you've planned your budget perfectly and aligned the end of every fixed term contract precisely with the point at which funding has run out. So all of your fixed term contracts are coming to their natural conclusion. That's how you've planned it. Arguably, no need to consult because everybody expected their contracts would come to an end. And it's not a structural change or change to your organisation. In the real world, it's a bit murky. And the consultation clause we would say, just as an employment lawyer, don't worry too much about whether or not it actually applies. Consultation is a good idea anyway. And consultation will apply if you've got an enterprise agreement, because it's a requirement as a required term under the Fair Work legislation. I'm just going to draw your attention to the type that's in red and in bold. If as a consequence of funding coming to an end, you're making alterations to your organisational structure, and it has one of the significant effects listed in clause 8.5, then your obligation to consult kicks in. And the significant effects include loss of a reduction in job tenure, alteration to hours of work, or job restructuring. So as I've said, if you're concerned about whether or not it applies, it's just a good idea to consult. We say as an employment lawyer, it generally good practice that you do this, and you'll have you're less likely to have disenfranchised employees, and they will feel like that they're being heard. What does consultation involve? Let's go back to that slide. Sorry, it means giving notice to the changes of all the employees who may be affected by them and their representatives, if they have a representative. Discussing with them and their representatives, if any, the introduction of the changes, the likely impact on employees and measures to avoid or reduce the adverse effects of the change, and commencing discussions as soon as possible after the decision has been made. So an invite to a staff meeting in which you discuss the upcoming changes to funding is generally a great place to start, but you want to make sure you've planned this and that you've done this with reference to when your fixed term contracts are coming to an end, and that you've given yourself enough breathing space if there is a notice period required under your fixed term or maximum term contracts. You should make sure your consultation takes place in advance before the notice period would begin for the first of those contracts to end, so that you are not overlapping. I would suggest that you advise your staff that you'll be undertaking an expression of interest process for ongoing employment where there are roles which would have funding for some positions but not others. Now, this isn't an essential process, but it is very useful in that circumstance where we've discussed a situation where you've got funding for, say, you initially had funding for 4 roles, but now you've got funding for 2. If you give your employees the opportunity through that EOI process to give feedback, for example, on whether or not they actually intend to stay, it's an important point. Some employees are already anticipating the end of their contract and have gone to look for employment elsewhere. You don't want to be offering employment to somebody who's already mentally left. But you also might find that some employees are prepared to put forward an arrangement of, you know, that they're happy with part-time hours, and in fact they want to seek that in relation in their next employment. So this is a useful process just for being transparent about the availability of funding, but also giving everybody an opportunity to put their option in relation to where they want to go with their employment, any potential future employment. This is where you'll be advising employees that selection is based on merit and performance over the term of their contract. So it's not an out of the blue announcement. It's something that they've been expecting. It's something that they have been advised of from the beginning of their engagement in your organisation. Now, you need to consider carefully the legal risks in the process for selecting for employees for further roles if they are available and not selecting others. I've highlighted at that 3rd bullet point the general protections under the Fair Work legislation. Now, decision might be unlawful if one of the reasons for deciding not to employ a prospective employee is a prohibited reason. And note, there can be multiple reasons for a decision, and you only need one of those reasons to be a prohibited reason for the whole decision to be unlawful. So an example is employee Anne Smith was a bit slow in her in performing her work. She came in a bit late and was quite inefficient. They also worked school hours, which you found inconvenient. If your decision not to employ Anne Smith is based on the fact this person worked school hours as well as those other reasons, this could be discrimination based on family or carers' responsibilities. I've just put in that bullet point underneath the discrimination at section 351 of the Fair Work Act, all those protected attributes, as we call them, that apply in relation to employment. And the list, I should point out that the list has grown since the SJVP Act came into effect and since Respect at Work has come into place. So be mindful of any updates to, for example, the prohibited the prohibited reasons for discriminating against an employee. I've also included their temporary absence due to illness or injury. So this includes terminating somebody if they're on sick leave that's been certified. Exercise of a workplace right, which is section 340 and 341 of the Fair Work Act. It's a very commonly utilised provision. Now, a person has a workplace right if they've got a benefit or right under workplace law, or they're able to initiate proceedings or make a complaint in relation to their employment. So it's a very broad list, and I haven't excerpted the section there. But it is a very broad list, and we commonly see employees making a claim that they have been terminated or they haven't been considered for further employment on the or they've been rejected or adversely treated on the basis of the fact that they've made a complaint in relation to their employment, which could mean anything. It could mean that they've complained about employee X is getting a different salary to them. And so there's the case law on this is very mixed, and I'm not going to go into great detail about this, but you just be mindful that if you have an employee who has made complaints or has raised grievances, and if you haven't addressed those grievances appropriately through your workplace procedures at the relevant time of that person making the complaint, that employee, the risk that that employee will make a claim that they haven't been considered for further employment, or, for example, their employment's been terminated early and in a maximum term contract situation, it's heightened. So you want to be making sure you've followed all of your processes in relation to taking seriously any complaints at the workplace level. I've included where an employee engages in industrial activity. So if you've got an active union member, for example, you want to be making sure that you're not offering them further employment on the basis of the fact that they are a union member. I've put in at the last bullet point just the Work Health and Safety Act in Queensland and the regulations. And what I'm referring to there is the recent changes that you will have seen in the law in relation to psychosocial risks and psychosocial hazards. There's a lot of focus now on there being a risk or a hazard associated with inadequate management and HR management of people. So if you've got an inadequate performance management process, if you haven't followed through with a complaint that you've received from an employee, if you're not managing bullying and harassment, for example, that all may contribute to a situation where you've got a heightened risk of psychosocial hazards. So this is where we're saying saying to PCBUs or persons conducting a business or an undertaking, be mindful that your processes are in place, that they're fair and that you're following them and that you're transparent, that you're making sure that your HR processes are adhered to at every stage. The last point is in relation to the separation. So this is the offboarding situation. You want to make sure that you're being clear with your employees who are unsuccessful if they haven't been offered further fixed term contract, that their contract is coming to an end for either for natural reasons, because it's the conclusion of the fixed term contract, and unfortunately you don't have funding for a number of roles. And you want to make sure that you are taking care of your employees in the offboarding process to ensure that you are meeting with them firstly to provide feedback on the performance on their performance throughout the entirety of the employment relationship. So rely on the term of their fixed term or maximum term contract in the letter of termination. And during the consultation process, you'll have given employees the option to look for work well before their notice period begins, if that's what they want to do. Be very careful when communicating any reason why an employee was offered, were not offered a further contract, and why somebody else was offered a contract ahead of them. You need to be specific about their own, the feedback is not in relation to any of the prohibited reasons. And you want to be making sure that not just that your decision, so the feedback is not in relation to a prohibited attribute or an unlawful reason, that you definitely are not making a decision for one of those reasons. Lastly, it's really important that you're offering your employees EAP assistance and resources where appropriate. You should ensure that if you've got a good employee, that you want to make sure that they're on file in case you have a situation where funding changes and there might be an opportunity in the future to give them further work. That you manage the offboarding process well, that you've given them feedback about their good performance over their employment life cycle, and that you have assisted them in the offboarding process, so that the likelihood of attracting them and re-beginning the employee life cycle with that employee is increased. Now that ends my talk on the presentation. I know we've got a couple of minutes left, so I'm very happy to take questions if Penny's there to field any.
Thank you so much, Araha. That was so interesting and really comprehensive, and I'm sure everybody found that really useful. There have been a few questions come through. A couple of them relate to the first part of your presentation around the fixed term contract, so I'll do those first. There's two questions here from Jessica. The first one is, would there be any exceptions for someone who was employed for, say, 1.5 years in one program, but then entered into a new contract for 8 months due to a maternity leave position?
That's a very good question. I think the second, given that the second employment it depends on whether they're doing the same role, and I think the test is going to be whether or not an exception applies in relation to either or one of those contracts. If the exception applies to the second role, then arguably you can say that that second position, if you're covering in a maternity leave contract, that's not counted in terms of the 2-year limitation on fixed term contracts, because it is clear that it's covered by one of the exceptions, which is, I think, C, 333FC, which is to cover a temporary absence. So that second, if the first term may be, now I forget what the first term was, but that both contracts might attract the exception, but it sounds like the second contract definitely would, because it's covering the absence of another employee due to maternity leave. And so that would not count in terms of that exception.
Okay, great. Yes, that makes sense. And so the second one from Jessica was, does the 2-year time frame start on the 7th of December 2023, or does it apply to any existing contract as at that time?
It will apply to contracts entered on or after 7 December. Okay. So if you've got a contract entered into prior to that time, it will, that should be okay.
Okay, great. All right, the next question comes from Ian. If the SHADS award does not permit fixed term contracts, does that render a fixed term contract under the SHADS award null and void? That is, for a traineeship for a fixed period or for an employee when the status of ongoing funding is uncertain?
If the award doesn't contain a provision, it still might be for allowing for fixed term contracts. It doesn't necessarily mean that the role is not covered by one of the exceptions. So the award is the modern award, and I think the examples are, for example, the sugar industry award, the higher education awards allow for fixed term contracts, but all of the other exceptions might apply in whatever circumstance. So you might have an employee who is covered by the SHADS award, but it is otherwise their employment falls within one of the exceptions under 333F for one of whatever reason. And you'll need to analyse each situation individually. Okay,
terrific. Thank you. Now, just note the time. We are coming up to time. We have a few questions to get through, I think, if people are happy to stay on, and you are as well, we might just work out.
Absolutely.
If that's okay? Yeah. So there's a follow-up question here from Jessica. Could it be a general protections claim, such as exercising a workplace right, if employers choose to employ people for no longer than a 2-year fixed-term contracts for no other reason than avoiding these provisions, thus saving redundancy and other potential claims?
So no. Oh, can you read that again? Because that was a meaty one.
Yes. Could it be a general protections claim, such as exercising a workplace right, if employers choose to employ people for no longer than 2-year fixed-term contracts for no other reason than avoiding these provisions, thus saving redundancy and other potential claims?
I think in the first instance, the prohibitions on fixed-term contracts and the anti-avoidance provisions would apply. So if you're entering into a fixed-term contract if you've got an exception that applies to you, then you can enter into fixed-term contracts, and it's not a problem. If the employer's motivation for entering into the fixed term contract is irrelevant if the exception applies. So if the employee has queried whether or not it is a legitimate, whether one of the exceptions does apply, then that would be dealt with under the new legislation rather than under a workplace right complaint. It will be dealt with under the anti-avoidance measures, and that can be dealt with through the procedures that the dispute resolution procedures that I highlighted earlier.
Okay, great. Yes, that makes sense. Thank you. Now, let me see, I was losing track of my questions here. Just bear with me. Sarah has just asked, is there a link available to the fixed term contract information statement as yet?
That's a good question. I don't think we have one as yet. I'm not sure if the Fair Work Commission has published it. Mm-hmm. I can go online and have a look now to see, after this meeting, to see if there is indeed one available. We've been monitoring the website quite closely to see if any changes are in line, but I don't think there is one yet.
Okay, great. Thank you. Well, if there is anything, I'm happy to share that with the people who've registered if it's available. But if not, it's just something they're going to have to keep checking on.
Yes.
Fair Work. Yeah, sure. The next question comes from Kate. Do employers seek advice from Fair Work about these changes and the implications?
You could go to the Fair Work Ombudsman, but the best you can come to us, of course, about whether or not an exception applies. We expect that there will be quite a bit of litigation in relation to whether or not a particular an exception applies in certain circumstances, because the explanatory memorandum, other than those examples that I gave you a bit earlier, is still a little bit, is not very helpful in some circumstances. We think that perhaps there might be some, we've been looking to see if any modern awards are going to be changed. There doesn't seem to be any inkling yet from the Commission to do that. But bearing in mind that they are dealing with it, there's a body of changes that are coming into effect in June that are probably occupying the Commission's time more than the fixed term contracts at this stage. So we would expect that over the next 6+ months, we will be looking very closely to see if there's anything coming out more in relation to whether or not there's regulations specifically describing the kind of funding under that exception that applies, or if there's any further guidance in this area. This is sort of putting it a bit out there, but there is also the ability for the Commission to vary modern awards to meet the objective. And if there is, at some stage there's the ability, we might see the Commission of its own accord varying the awards to provide for the fixed term contracts if it's made by application of a number of interested parties saying, hey, we need this in our industry. So, but coming back to the original question, yes, you probably can call the Commission, but they're not going to be particularly helpful at this point in time, I don't think. I think probably your best bet is to get an analysis from a lawyer as to your particular kind of funding arrangements, and a case-by-case analysis of your employees, because they don't tend to give specific advice depending on your individual circumstances.
Okay, great, thank you. This question comes from Jenny. Many community organisations have philanthropic short-term funding. Is there potential for this to be viewed as an exception?
It's a good question. At this stage, I'm not sure. It doesn't look like there's going to be any change to the legislation. If the connection would be that the funding has to directly fund an employee's role. So the carve out in the legislation around funding is that the in consideration of that particular exception is that the funding must directly, in whole or in part, finance that position. But just because the funding exception might not apply, there might be other reasons that you could look at. For example, if that person is performing a distinct or identifiable task, which is the first of the exceptions, if you're employing somebody to do a particular project and it's project managed for a short period, then that might fall into one of your exceptions.
Okay, I think that makes sense. And, there's obviously a long way for this to run yet. And I think there'll be plenty of people in our sector and beyond who'll continue to have lots of questions about it. So we might leave it there. That's the end of the questions that we've received from people for today. So thank you very much, everyone, for your engagement and your questions to Aroha. Thank you for your time and expertise, Aroha. That has just been terrific. I'm sure that everybody has taken a lot out of that, particularly as this emerging area and the level of change is going to impact people quite significantly, I think. So thank you very much. That's it from us. Before you go, just a reminder to complete the feedback survey. That'll pop up on your screen once the webinar is closed. That does help us to continually improve our webinar program. So if you could take the time to respond, we'd really be grateful. Thank you again to our wonderful presenter, Aroha Greenwood, and to all of you for participating. And we'll look forward to seeing you at our next CLCQ webinar. So it's bye for now. Thanks very much.
Thanks, Penny.
Thank you.